Welcome to the official Lawyer Minds podcast. Lawyer Minds is an ever-growing ecosystem for all the resources modern lawyers need. As the official Lawyer Minds podcast, we'll discuss everything from the latest happenings on the website to industry news. Get ready. Here we go. It's time to dive into the minds of successful lawyers. Here are your hosts, Tad Thomas and Mike Campbell.
Mike, we're going to have a great podcast today.
Yeah, I always like talking about trial strategy because I'm just from an academic standpoint, and I know that this guy's going to have a lot of information for us.
So the way I met Robert, we actually taught a seminar together on jury selection down for the Houston trial lawyers a couple of months ago. And he actually helped me with my presentation even and gave me some of his slides. And we spent maybe an hour on the phone just talking about my particular topic. And then, I got to see him speak and see his topic and work with him in small groups a little bit as well. And, just a lot of really good information, how we've gotten so scientific about, picking juries.
Yeah. So I think you may have already shared this with the pod, but what is if you could pick out a moment during jury selection that sticks out to you, whether it's funny or frustrating or, anything in between, what sticks out to you?
Well, I'm assuming you're talking about one of my most recent trials. Talking about when the female juror came down and passed off the phone number to me and said, "I need you to call me."
I don't know. I didn't know if that was it. Or
yeah, we might want to cut that one out of the podcast. Yes, I had a juror come down, and I don't think it was a solicitation for a date. I think it was she needed legal representation.
That must have been
and
it.
So she was asking me to call her about legal representation. And interestingly enough, that was the second incident of juror misconduct in 2 days and I had not seen it in 20 years. So
yeah. That's better than mine, where I was told by the judge that I was doing jury selection all wrong, and then told me how I should do jury selection. And then I had to walk back to the podium after the jury just heard that I was doing jury selection all wrong, according to the judge. And then I go back into the way I was doing it. So,
oh, wow.
Yeah.
Yeah. Well, this is going to be a great podcast. Can't wait to hear Robert talk about the jury selection. So without further ado, Robert Swafford on jury selection.
The Lawyer Minds podcast is brought to you by Gavel Video. Some companies do videography, but Gavel Video does high-quality cinematography to highlight your firm's successes. Also brought to you by Legal Insights, providing expert digital marketing for law firms. And finally brought to you by iLitigate, trial presentation software for trial lawyers by trial lawyers. And now to our program.
Robert, welcome to the program, sir. How are you today?
Oh, man, I'm great and happy to be here with you guys.
Well, I'm really excited to have you on. I had the privilege of meeting you we taught a seminar together down to Houston trial lawyers, and that was my first exposure to you, and I was very impressed. So I'm really excited to have you on the podcast today.
Well, I'm really happy to be here.
So why don't you talk to us a little bit about, I'm really curious how you got into jury consulting with a focus, in jury selection. I know you graduated from Baylor Law School. Kind of tell us about how you ended up here.
Well, when I went to Baylor Law School, the way people were taught to do jury selection was basically give an opening statement during jury selection. So the entire focus was on basically trying to sell your case. And so you'd hear people do questions like, well, does everyone here agree that anybody can sue anybody for anything? And I take it by your silence that anybody can agree to sue anybody can sue anybody for anything. And it doesn't mean that anybody's ever done anything wrong. So that was like a classic defense lawyer voir dire, which obviously that kind of question is not designed to get any information. It's not designed to get strikes for cause. It's only designed to try to prep or lay the groundwork or sell your case. And then on the plaintiff side of that would be questions where people would say, well, you would agree with me that it wouldn't be enough just to pay somebody's medical bills if they had suffered a grievous accident, that simply wouldn't really take care of all of their costs. So that was the way it was done and the way it was taught. And believe it or not, so that would have been 1985. That I was in practice court and people were teaching me that at Baylor. Yesterday, I picked a jury and a defense lawyer, hand to God, stood up and said, does anybody here believe that just because we have a lawsuit today that someone's done something wrong? Okay. So just because, that is an utterly defunct and discredited way of doing jury selection, and has been for at least 30 years or more, there's still people who do that, right? And so, but that's when I was taught in law school. And I was very fortunate in that around 1986, I went and saw a woman speak named Kat Bennett. And Kat Bennett was not a lawyer. She was a psychologist. And she came up with this really amazing idea. Since we have an opportunity to ask questions of a panel of people and find out what the attitudes, opinions, life experiences, and feelings of these actual human beings who may be judging our case, why don't we ask them questions about that and then listen? That was like strangely mind-blowing. Okay. Why don't we find out something about the people that we're making decisions about instead of just saying, oh, somebody's wearing a bow tie. I don't put people with bow ties on my jury.
Right.
Which, believe it or not, is how people made decisions and still how some people make decisions.
Robert, would you say that when they used to do jury selection, they would almost try to convince the jury of their case or try the case in jury selection?
There are a couple of different things that they would do. They would either do sort of like broad hypotheticals of, just because this, right? Some kind of principle thing. Or they would talk about burden of proof, and if it were a criminal case, they would say, well, there's clear and convincing evidence. And clear and convincing evidence is evidence if you're going to take someone's child away. But way, way beyond there, is beyond a reasonable doubt, right? They would ask questions, sort of on a broad sense. And then there are some, lawyers that would essentially feed little bits of facts, about the case. They would say, well, if you were to find out such and such, how would that occur, right? That was the state of the art at the time I got out of law school, with the exception of Kat Bennett and a few other people, who were entering into the field and basically creating the field of jury selection or jury consulting. Whenever you're doing jury selection, you have a couple of choices as to what you're up to. You're either trying to get rid of people to get information, either through your information for your peremptory strikes or maximizing strikes for cause, or you're trying to sell your case. Those are really the only two choices. And the reason people were trying to sell their case is there were all these studies that showed that people had made up their mind at the end of voir dire as to who should win the case. And so what people read those studies to say, oh my gosh, I've got to get my licks in early. And so the studies are based on the idea of confirmation bias. And confirmation bias, as everyone knows, is that you tend to reject facts that are inconsistent with what you believe and either magnify or make up or, totally out of whole cloth, create facts that support your view. And so the idea is that primacy and recency, I've got to get my licks in. And if I don't do that during voir dire and the other side does, then I've lost, right? Now, that was a misreading of the studies because the fact of the matter is people had made up their minds about your case before they ever got up that morning to drive to the courthouse. Some people had made up their minds about their case 30 or 40 years ago.
It's a pretty important distinction, right?
Right.
That's a big, I mean, because then I guess that leads to what you were talking about with Kat Bennett and how that developed and learning about these biases.
Well, first of all, demographics are the least likely predictor of how somebody's going to respond or make a decision in a case, right? It's illegal to make decisions based on race, but it's also stupid. Like if you're making decisions based on race, then you didn't do a very good job on voir dire. So if you come in and you say, "Wow, I've like the big catchword in jury consulting right now is big data." Like, oh, we have big data, right? Well, like how does that translate into something I can actually use, right? So if I have all this big data saying retired teachers are good for my case, and I have the one retired teacher on the planet who hates my case, and I don't ask her any questions that would identify that she happens to be the person who's the worst person that I could imagine to be on my jury, and I had an opportunity to do that because I had looked at the big data, then that was, it's pretty idiotic, right?
Oh, yeah.
And so developing questions that actually inquire into what are the attitudes, opinions, life experiences that could influence the case or how they make decisions of the individual human beings who happen to be out there, as opposed to making some kind of decisions with the peremptory challenges based on some demographic is, really sort of absurd when you think about it.
So how did you get into jury consulting as your primary occupation as opposed to practicing law?
Yeah, well, so what happened was I started using the Kat Bennett version of asking open-ended questions like, tell me your feelings about police officer testimony. Tell me how you feel about intangible damages. What are your thoughts about personal injury cases? And I got all this information. And so that's essentially, the kind of questions that, Kat Bennett, Robert Hirschhorn, Lisa Blue, and, most other jury consultants that you would listen to would say, and it was very, very valuable. So I had all this information, and this was like sort of at the beginning of the tort reform, movement. And so I would go back in the jury room to do my peremptory strikes, and I would look at all this wealth of information I had and realize, wow, if I had 25 peremptory strikes, I might have a chance. But I did.
Right.
I mean, some of the cases I was trying back then were county court cases, and I had 3.
Yeah.
And so we have this problem, right? So I can't, there's no way I can win unless I can get more people struck. And I have a limited number of peremptory strikes. And so I started developing my system, which is the strike for cause method of jury selection. And so with the strike for cause method of jury selection is asking questions in such a way that I can get people to admit their biases and prejudices such that they are struck for cause. And by developing that system, I started getting many, many, many strikes for cause. Yesterday, we cleared out large numbers of the panel and had to make like I had to count and say, okay, am I going to ask for all of the ones I could get? Because, we actually wanted a trial. We're not going to bust it, right? I think, I've gotten as many as 75 strikes for cause. And whenever I say 75 strikes for cause, I'm not saying 75 strikes for cause of people who are biased and prejudiced. I'm saying 75 strikes for cause for people who are biased and prejudiced against me. Wow. And holding on to the people who have a bias for me. Because the fundamental to the system is the recognition is that the nature of being human is to be biased and prejudiced and have no insight into the fact that you're biased and prejudiced. That is your entire jury panel. There is no such thing as a fair and impartial jury. So here's the question. If I get 75 strikes for cause, if I have a panel of 100, I get rid of 75.
You've struck the whole panel. Oh yeah, you kept, and you have how many? There are 6 jurors remaining. You got 3 peremptories. You've set yourself up to where, depending on the number of jurors that are allowed, you've pretty much ensured that the jurors you want, who are not biased against your case, are going to end up on the jury itself. If everyone's biased to some degree and they aren't aware of it, and you're saying we've gotten rid of the biased people who are biased against us, then the natural conclusion is that if the people remaining are biased, they're biased for us.
That's correct.
Okay.
And people make decisions not based on how the world is, but how the world occurs for them.
Right.
And people's occurring world is a combination of 2 things. It's a combination of phenomena, which would be, the facts, arguments, exhibits, demonstratives, et cetera, and the filter through which that phenomena goes through. So if I take my glasses off, then you get blurry, okay? And I relate to you as blurry. I put my glasses on, I relate to you as sharp.
Right.
So the deal is that your jury panel has glasses on, and they will never, ever in the course of a trial, be able to take those glasses off, or sunglasses or rose-colored glasses or whatever they are, right? They will not, they will not be able to take those off. And the second thing is they don't know they have glasses on. They think they are fair and impartial and only make decisions based on the facts of the case.
It's either they're biased against you or biased for you. Is that?
Yes.
That's the premise. Very interesting. Okay. I like it. Okay. I got, Tad, you got a question. Go for it.
Well, I mean, when you say that everybody by nature is biased to one side or the other, then that begs the question, why do we ever have jury trials anyway? Because it's either you're at the outset, everybody's biased, and it's just a fight to see who gets the most biased in their favor on the jury, and that there is no such thing as an unbiased jury, and therefore every trial is a fraud. I mean, is that not the argument? Fraud's a little strong. We'll do a little bit more ontological. Okay. What I do on a daily basis is witness preparation. So we're going a little bit far afield from jury selection.
No, but it's important. Witness preparation, I harp on this all the time, is one of the most important parts of any case, right?
So I just happen to have a legal pad that I used recently. Okay. So I'll show you what it looks like. Okay. So I have 2 circles. I have a Venn diagram, right?
Mm-hmm.
And one of the circles says doing,
pick up.
Yeah. The other circle says being. Right.
Yeah, doing and being. Yeah, absolutely.
Doing and being. So I can pick up a pen and I could be careful picking up the pen. I could be angry picking up the pen. I could be arrogant picking up the pen. And there are ways of being that are consistent with winning, and there are ways of being that are inconsistent with winning. And so the doing that we really do when you're testifying are the words that come out of your mouth. So I could say, yes, sir, and be respectful, or I could be, yes, sir. I could say, yes, sir, and be arrogant or sarcastic. Yes, sir. Right.
Mm-hmm.
And because jurors make decisions emotionally and then go back and rationally justify the decision they've already made, if you have a witness that is coming off as arrogant or angry or some way that doesn't work, then your chances of winning go way down. Mm-hmm. Right.
Yes. Yeah.
And so the question is how does one shift that? How does someone shift someone's way of being? And believe it or not, we're going to get to the answer to your question about what are jury trials. Okay.
Mm-hmm.
And the way one shifts someone's being is making a distinction between fact and story. So fact is something that's objective, right? Another way of saying fact is like, well, what are the what so of the situation? And story is, what do you make it mean, right? Like, what's your interpretation?
Mm-hmm.
So one thing that's true in all of my cases, and at this point, I've literally prepared thousands of people to testify. Yeah, I picked almost 400 juries, but in terms of witness preparation, thousands, right? And one thing is true on 100% of all of my cases is it is a fact that my client is in a lawsuit. And that's a fact. I don't get hired unless like trials next week, basically, right? And all of my clients have the same story. And whenever I say my clients, I've had, a half dozen billionaires I've prepped. And I've had people who have been injured in accidents who make less than minimum wage, who are immigrants to the country. And it didn't make any difference what kind of case it is. If it's a trade secret case or a criminal case or a catastrophic injury case, all the clients have the same story. And that is, I should not be in a lawsuit 100% of the time. So if it is a fact that you're in a lawsuit and you have a story that you should not be in a lawsuit, what does that produce as a way of being?
Well, there's a conflict there. And you're also very frustrated about the fact that you're having to sit through this process.
Yeah, I shouldn't have to be going through this. I was clearly wrong. They should just write a check.
Yep.
Or we didn't do anything wrong. And why should this greedy plaintiff's lawyer, or we would give him some money, just not $1 billion, right?
Yeah. And that is the saying that we hear that from a lot of our clients. Why won't they just do this? And so I agree 100%. Yeah. I see that all the time.
Yeah. And so here's the thing, that if it's a fact that you're in a lawsuit, you have a story, I should not be in a lawsuit, and that makes you frustrated and angry, and frustrated and angry is inconsistent with winning. And what we're interested in is winning, right?
Yeah.
You have to go back and you say, okay, can I change my facts?
No.
Change
your story.
No. Can you change your story?
Yeah.
Yeah. So you see, that's marked out. Like, I perform this miracle almost every day. I should be in a lawsuit.
All of a sudden the light goes off, right?
I should be in a lawsuit. This is how we resolve disputes in America. Not through pistols at dawn, not through flipping coins, not through drawing straws. I had a client who is from Somalia. He came over to the United States and was injured in an accident. And when I got to that point, he's like, oh my gosh, this is so great that you're able to resolve your disputes. Because do you want to guess how they resolve disputes in Somalia?
I have a few guesses. I'm sure they're all wrong, but
AK-47.
None of it involves a jury trial.
None of it. Yeah, right.
AK-47s. His entire family had been wiped out by a rival tribe, and he was able to escape.
Yeah.
Yeah. He comes to the United States, says, wow, you resolve your disputes through this method. This is incredible. And here's the thing is that I have represented countless people who have had family members who have been killed. I have represented people who have killed people. Mm-hmm. I've represented people where millions and sometimes hundreds of millions of dollars are going to change hands. And in every single one of those cases, everybody lives with the result.
Right. And it's interest. It's fantastic. That's the word. It's fantastic to have that perspective that your Somalian client shared with you, because we are so far removed from a time when those were how disputes were resolved. And sometimes we lose sight of how awesome and as imperfect as it is, wonderful our system of justice can be.
Yeah. Do y'all know what a bandito is?
Yeah, sure. Mm-hmm. Bandit.
Yeah. And so I represented a bandito one time who the agreed facts are the agreed facts, and it's on video and everything. Okay. He rolled up on his motorcycle, got off of his motorcycle, went into a crouched position, shot and killed a Cossack, and walked up and made sure that he was dead. Okay. I mean, that's what it looks like in the video, right? And in the process of a bunch of other people being killed at the same time. And that case was dismissed.
Oh, wow.
It was up in Waco as a Twin Peaks case. And I don't know if y'all heard about that, but there's this big melee between the Cossacks and the Banditos. And my client's case was dismissed and went through the judicial process, and he's not looking over his shoulder.
Right. That's it. Yeah, exactly. There's no retaliation having to get retribution,
There's a process.
That's right. How does this kind of relate back to your view of juries and how you consult people whenever they're looking at striking jurors and in the voir dire process?
Yeah, well, so ultimately, what Tad's question was as well. Well, because people are biased, what's the point of a trial? Well, the point of a trial is that we have civil society and the rule of law, and that's enough for me.
Yeah, Tad. Isn't that Tad? Can't that be enough for you?
I go back to my original premise, though. If we are of the opinion that every juror is biased toward one side or the other before they ever set foot in the courtroom, then is the only way to win a trial jury selection, essentially, and everything revolves around that. And then once you pick your right juror, then, the next week or 2 weeks or however long you're in there is just for the attorneys not to screw it up by putting in evidence that makes them biased against you for some other reason than you anticipated.
Yeah.
I
do leave after the first day.
Because the job's done. So you come in, you help me pick a jury in Eastern Kentucky, and you're like, Tad, we're done. You got a good jury. Don't screw it up from here, Tad.
Yeah, if something goes,
if something
goes cattywampus, it's on you, Tad. We got a winner.
Right? Yeah.
Well, here's what I say about that. I'm not saying that the phenomena doesn't make any difference. Okay, like I spend lots of time, helping people craft their message, to try to make sure the message, resonates with the people who are sitting there. Certainly, we wanted to exploit biases like anchors and adjustment to make sure that we have big anchors that the people are going to relate to. I certainly don't want them to hate our clients. So I help with direct. Because I'm an attorney, I make an appearance on my cases, right? Mm-hmm. And so I don't really have a lane, right? Most jury consultants are psychologists or sociologists. So I'm asking people, hey, is that going to come in? Or what's going to be in the court's charge, right? So I'm very involved. I'll tell you a funny story. Because I'll get the jury in the box, but then I'm talking to the lawyers every day after that, right? So right after I picked the Alex Jones jury, I had to get on a plane to fly to California because I was picking a jury in a trade secret case against Apple. And there's a 2-hour time difference, so I could start very early in the morning working on my case in Texas, and then work on my Apple case, late. And I was talking to Mark Bankston, who's one of the attorneys, and I was making some suggestions about cross-examination. Because I've done so much witness preparation, I sort of know, by preparing people how to deal with the difficult cross-examination, I know how to craft a difficult cross-examination for certain kinds of people, especially narcissists. So I was talking to Mark. And I said, I had several suggestions, and he said, okay, well, this is a good suggestion, but this is you don't know him as well as I do. That's a bad suggestion. We're not going to do that one, Robert, which is fine. I'm very collaborative, right? Not all my ideas are good ideas. And so after I'd finished giving all my ideas, Mark says, well, Robert, do you want to hear what I'm going to do in Cross? And I said, yes, I'm really interested. Sir, I've been talking, I've been listening. And he says, yeah, I'm going to ask him, did you know that your lawyer messed up and sent me a digital copy of your entire phone? And I have all your text messages and email messages. And that's why I know that you're lying to me. And I said, okay, Mark, yeah, my questions are terrible compared to yours.
And that was the question that was like broadcast to the whole universe, right?
Yeah,
right.
Yeah, you win.
Yeah. When you were going,
in addition to winning the case, that question gets in publicity all across the country.
Right. When you went into the Alex Jones case, specifically using the method, the strike for cause method, what were you kind of communicating, or what can you communicate about what you were explaining to the lawyers, and what are they looking for, and what questions are they looking to ask, particularly in this big of a case and public case?
Yeah. Well, so this case is no different than any other case, just magnified. Okay. And so if I had 3 people on that jury that believed that there were lizard people that were part of a conspiracy and a cabal that are running America, and that Hillary Clinton is running a pedophile pizza ring or a pedophile ring out of a pizza parlor, and that those children weren't killed, then we had a mistrial, right? We would never be able to get to a verdict, right? Because you can have a 10-2 in a civil case in Texas.
Okay.
But if there were 3 of those, on the jury, then we have a mistrial. Okay. And so on the one hand, we had to get rid of all of those people, right? And not just all of those people, but all the people who maybe don't go with the QAnon stuff, but think that Alex Jones is an important alternative voice that's squelched by the mainstream media, and this is just an attempt to try to shut down efforts to make America great again. So I had to get rid of them too. So if we didn't get rid of all of those, then there was no chance. Okay, so that's part of the equation. The other part of the equation is that this is Texas, but this is Travis County, Texas. And Travis County, Texas has always been described, or Austin in particular, has always been described as a blue dot in a red sea. Although that's flipping some now with, the major metropolitan areas in Texas now, do have blue courthouses, for the most part. But Austin has, always been, keep Austin weird. It's this progressive college town, center of government, tech, and so there are a large number of people in Travis County who hate Alex Jones with a white hot heat walking into that courtroom. So I had to hold on to them. Otherwise, we didn't have a panel. Like, we would not have had a jury, right? Like, even with 100 people, if the defense had been effective at all in getting rid of people, then it would have burned the panel. And so it was really challenging, and so so what I would say is, even though it's a liberal jurisdiction, even in liberal jurisdictions in Texas, there's a substantial number of people who are, listening to talk radio, who are listening to Joe Rogan and then buying into some of the worst parts of Joe Rogan, even though Joe Rogan's, not Alex Jones. There are lots of InfoWar fans in Austin because this is where he's based. It was essential to get rid of the people who are biased against us and to hold on to the people who are biased for us. Because in that case, as in all cases, there was no middle ground.
Right. So when you say hold on to the jurors that were biased in your favor, were you just avoiding the questions to those, or were you affirmatively doing something to inoculate them against the defense voir dire?
So all the questions that I write are designed to identify people who are bad for me on whatever side I get hired on. Okay. And right. So on this side, I'm hired by the plaintiff, right? So an example of a strike for cause question is, people have strong feelings about certain types of damages. There's some people, if they were on a jury, could award money for lost wages, medical bills, pain and suffering, even punitive damages. There are other people who are on a jury could award money for lost wages, medical bills. They simply could not award money for something intangible like pain and suffering, mental anguish. Who here fits in the second category? You could award money for the lost wages and medical bills. You simply couldn't award money for something intangible like pain and suffering and mental anguish. Who here fits in the second category? Please raise your numbered cards. And then we read off the cards. And then we go after each one of them individually. Tell me about that. Oh, I don't know how you would ever quantify that. Or people just make stuff up. So is it fair to say that regardless of the law, the facts, or the judge's instructions, you simply could not award money for something intangible like pain and suffering and mental anguish? Is that fair to say? Yes, it's fair to say. And I put a big X on my chart. And then the next question after that is who agrees with this juror? Please raise your numbered cards. Okay. Mm-hmm. And so the questions are not asking who can do it. The questions are asking who can't do it. Mm-hmm. So that's the first thing we're doing. So the second thing we're doing is we're asking if you trip on somebody who happens to be good for you, right? And they, so as happened, as one person says, well, had her card up. And I thought, man, this is really surprising because based on the supplemental written questionnaire, she should be one of ours. So she had her card up and she says, well, what about people like me? And she says, what do you mean? Well, I would give all the money. And we said, what do you mean? All the money there is. Like right now, I would give all the money there is, right? What we want to say to her is shut up.
Right.
I wasn't talking to you.
Yeah, but you can be fair and impartial, right?
Yeah. But we don't do that. We listen politely, and then we ask, who has a different opinion? So you either say, if you have a juror who's bad for you, say who agrees. If you have a juror who's good for you, who has a different opinion? And that gets you back into the people who are bad for you. And so then the third thing you can do is you can inoculate. And this is sort of anticipating that the other side, knows what they're doing or actually is any good. So if you're a plaintiff's lawyer and you're concerned that the other side may get strikes for cause on sympathy, then what you do is you say, listen, I'm about to sit down, but I want to talk with you about one of the judge's instructions that I expect to be given, and that's an instruction that you're not to let sympathy play a role in your decision in the case. I want to let you know that we strongly agree with that instruction. We are not here for sympathy. Our families have plenty of sympathy from many sources. We're here for justice. There's not going to be an instruction saying that you are not allowed to use empathy. Sympathy says, I feel sorry for you. Empathy says, I understand. Well, we do need people who understand pain. And there's not anything that prevents you from doing that. Now, the question I have, is there anyone here who feels like because of their sympathy, you're not going to make me prove my case? Just rule for me because you feel sorry for our clients, but we don't want that. Is there anybody who feels like they can do that? And then you don't hold for an answer, okay? You just roll through. I didn't think so. And then you roll through. Okay, so that's an inoculation for the other side. Now, fortunately, in this case, defense counsel, although he was very skilled in many ways, the defense counsel in this case was not skilled at voir dire. And so in Texas, we have something called an improper commitment question. So an improper commitment question is a question that asks the jurors to commit to something based on a fact in the case, one way or the other. So the classic case that came out was a case where a little girl wasn't wearing a seatbelt. Plaintiff's lawyer stood up and said, my client wasn't wearing a seatbelt. Who here on that fact alone would find against my client? And burned a panel. And then he burned another panel. And then the judge said, you're not going to ask that question again. And ever since then, in Texas, it went up on appeal. And ever since then, in Texas, you cannot ask a question asking a jury, what are you going to do on a specific fact in the case? Mm-hmm. And so the defense lawyer stood up and said, well, the families, the plaintiff's children were murdered. Who here, because of that, would have sympathy just so overwhelming that it would play a role in the decision in the case? And in this particular case, the judge had made a ruling that like I'm not crazy about, which is that only one lawyer could talk during voir dire, which is like, there's maybe two judges and the hundreds of judges I've been in front of who have that rule. And it's not in the rule book, right? So I have to whisper or pass notes. All my other cases, I make an appearance and I actually argue all the strikes. I do all the objections. And so, but in this particular case, I had to turn around and in a big stage whisper to one of the lawyers on my team, objection, improper commitment question. And he was on top of it too. And I said, Judge, do you have an objection? He said, objection, improper commitment question, sustained. And then he tried again, objection, sustained. And then he tried a third time, sustained. And then he could never ask the question properly. And so he moved on to another topic, which was like, just.
That's a biggie. That's a biggie. I mean, I'm sure he was probably like floundering. I don't know how I'm going to then get this information because it was important to them to figure it out. Right?
Well, it's not even about that. It's about that he could have gotten a bunch of strikes for cause.
Sure. Yeah. For the sympathy.
Yeah. And the only strikes for cause he got in the case were at some point people just couldn't constrain themselves anymore who are our people. And during his voir dire, not because he elicited it or asked any questions that were designed to get that information, just started giving speeches. You have to understand, this isn't just about this. This is about January 6th. And then somebody else was saying, this guy has a megaphone to the whole world. And then someone else, then juror 20 started her deal again, right? And so he didn't actually legally establish what it would take to get a strike for cause because he didn't know how to ask the questions or at least he wasn't asking the questions such to do that. But the judge, sort of in abundance of caution, granted everybody's request for strikes for cause. And so he got a few, even though he wasn't going for it. Obviously, we got many more, because that was our focus. His focus clearly was trying to do a selling voir dire. And if I were to guess, like where he was coming from, is probably he had been to the ranch or been trained by somebody who'd gone to the ranch. Yeah, y'all know what I mean by the ranch.
Yeah. Let me play off that a little bit because what part of me wants to say, okay, look, I understand that we are all part of tribes. It's evolutionary. We've got these confirmation biases, and we're gonna cheerlead from one side or another. But then another part of me is saying, yeah, but if I'm authentic and credible and open and honest with the jurors, they'll follow me, no matter their biases, their prejudices. And what do you have? What do you say back to that part of me that feels that way? That's compelled to see that humans have the capacity to get past that bias, past that prejudice.
Well, you're delusional.
Thanks, Robert.
I've told him that for years, Robert. I've told him that for years.
Okay, so all right, what else is?
But you're not alone.
Yeah. Because I mean that's part of your concept, right? Is we're unaware, we're not aware of this. Yeah.
Yeah. Well, and I would say that's probably a bias you have.
Yeah.
An unexamined bias that probably serves you in some way.
Do you think? Do you think it? And I'm not tearing out my psyche here, but with a trial lawyer, it might be like, look, I have some agency in this, right? I have some role in developing my skills, and my skills of convincing people are so elite, blah, 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 blah. Right.
Yeah. Yeah. I mean, there's no question. I mean, because the logic of this is just impeccable, right? Like they're unassailable. Any branch of psychology will tell you that we're a collection of unexamined biases. There are tons and tons of research about implicit bias. There's the IAT, like you can go on. Ted, you're nodding your head. Tell them what it is.
And so it's the online test where it's got multiple different tests where you can test your implicit bias.
Oh, sure. And yeah. I've done that.
Robert's actually the one that turned me on to this when we were teaching the seminar. He goes, go take it. We can put that in the show notes. We'll put the link to the IAT in the show notes so everybody can see it online and take the test. It's really interesting.
I've done ones where they flash the photos of people's faces across and you have to respond. It's similar to that.
Yeah, and so the deal is that the only difference between me and any of my jurors is that I'm ongoingly examining my biases. Like I'm always working to see my biases. Now, here's what I would tell you is that being authentic always works, right? Like I try not to be contemptuous, okay? Because that's a way of being that doesn't work. I know that, right? It's one of my habitual ways of being that doesn't work. but sometimes I can't help myself. So some lawyers, I'm not saying the lawyer in the Alex Jones case, do things that occur for me as manipulative and cheesy. And so he said, he started out and he said, well, what does brutal honesty mean to you? Juror 1. And what does brutal honesty mean? Juror 7. What does brutal honesty mean to you? Well, that's what we want today. It's brutal honesty. And I need you to talk with me. And juror 3, will you talk with me? Yes, I'll talk with you. Juror 7.
Real quick, the defense lawyer was doing
the defense lawyer was saying this. Yeah.
Oh, okay.
And juror 4,
okay.
Juror 7, will you talk with me? Yes, I'll talk with you. Right now, this is after we had more than an hour of jurors expressing their biases and prejudices fully and getting struck for cause by somebody who is authentically curious and interested in what they had to say.
Yeah.
Not somebody. Right. Not somebody who's doing some kind of trick, right?
Right.
And then, would you agree with me that freedom of speech is important, right? What does freedom of speech mean to you, right?
Right.
And just, cheesy stuff. So I'm not saying any member of our team actually did this. I think there were members of our team who at some point wanted to say, "Will you talk with me?"
Yeah. So I want to wind up with one question, because what you just said leads me to this. So, so many judges have seen that first style of jury selection where all it is doing another opening statement, indoctrination. And because of that, they've gotten so pissed off at trial lawyers for trying to do that. They've said, I'm giving you 30 minutes and no more. And so in a lot of our jurisdictions, we're capped at a certain amount of time. So what advice would you give for those trial lawyers in those jurisdictions where you just have a hard judge that says 30 minutes, you filed your motion saying, I need more. They've said, no, you got 30 minutes. Where should they go?
So I write voir dires that, I write basically what I do is when someone hires me, I hear about the case. We do focus groups, when the case warrants it. I write scripts, and then I show up and I help them pick the jury, right? And then we do witness prep and help with opening statements, et cetera, right? Sort of soup to nuts. But the scripts that I write will sometimes, have like 26 questions, right? And the lawyer will say, well, there's no way we'll get to all 26 questions. Well, yesterday we had an hour and 15 minutes, and we got through all 26 questions and got information, got all of our strikes. We got different strikes for cause on different questions. Like sometimes different things hit, right? Sometimes mental anguish hits, sometimes burden of proof hits. Sometimes credibility of medical professionals. That was hitting yesterday. Who here, with all other things being equal, would tend to give more credibility to a medical professional than to a patient? If there's a swearing match, who would here would just tend to have to favor the medical professional? Please raise your number cards. And I'm not talking about because of their expert training or anything. I'm just saying about whether or not they're going to tell the truth. And so that was a question that got a bunch of strikes. Okay. And so, what I tell people though is the point of the exercise isn't to ask every question. The point of the exercise is to get rid of every bad juror. And so if you have a question that works, just work that question until it doesn't work anymore. So if you gave me 30 minutes and I had mental anguish and I was efficient, in terms I was using, I could probably get you, 20, 25 strikes for cause, in a conservative jury panel in 30 minutes, And so now the other thing is if you have a script, if you have a written script of questions, then you come to the end, you say, Judge, listen, I wasn't able to ask whether or not somebody has ever adjusted claims. I was not able to, and I did not waste a minute talking about brutal honesty or how the burden of proof is just one piece of paper, or how will you talk with me? I did not waste a second. I got straight to the questions. I didn't talk about how important jury service is. We didn't do any of that. We just asked questions. And I still was not able to ask whether or not I was not able to follow up with everybody who worked in a medical profession and how that might affect them. I was not able to ask people who have legal backgrounds, and I have the questions written out right here, Judge, and I'm going to read them into the record to show that
they were fair questions.
That I did not have sufficient time to sufficiently ask the questions that I needed.
Fascinating.
I'm going to preserve my record on that.
It's brilliant advice. Brilliant advice.
Before we go, let's just talk about supplemental written questionnaires.
Okay.
And so So you can't do them in every case. Big cases, you can usually get them though. Yeah, supplemental written questionnaire is a questionnaire that you send out to the panel in addition to their basic demographic card that the court would normally send out. And so in the Alex Jones case, what was key in jury, one of the things that was key was the supplemental written questionnaire, and collaborated with Mark Bankston and the rest of the team, and then collaborated with my assistant, my associate. Yeah, he's a young lawyer, very hip, and then my son, who is tied in, socialist, but tied into all the edgiest stuff, right? Hipster socialist, tied into all the edgiest stuff. And what we did was we had a category of, on a scale of 1 to 5, how do you rank, the following media personalities? Hannity, Rachel Maddow, Jordan Peterson, and so Alex. So we went through all these different people, and so if someone had Biden at a 1, meaning low credibility, and Trump at a 5, that told me something, right? If someone loved Joe Rogan, but also loved Rachel Maddow, that told me something too, right? If someone hated Tucker Carlson,
didn't understand the question.
Yeah, but no, Joe Rogan sort of, he's sort of like blank slate, right? So he just agrees with whoever comes on the show,
right?
And so it's harder to categorize, but still bad for us, What media sites have you visited or gotten information from? 4chan, Reddit, like listed all of those, right? What are your feelings with regard to gun violence? What's the major cause of gun violence? A lot of plaintiffs like to ask, what's the major cause of homelessness? Right? Well, that'll tell you something on that one, right? So supplemental written questionnaires, are very important. I have a police officer shooting case up. Have you posted, commented on, liked any comments such as Blue Lives Matter or All Lives Matter? My police officer shooting cases, I want to do those. Now, why am I saying have you commented, posted, etc., with regard to these things? Well, because I'm going to do my social media research if I have time, right? Mm-hmm. And if they answer the question saying, no, I've never done that, and then I have it, right, that they have done it, like them posting on it doesn't get me a strike for cause. Mm-hmm. Them lying about it gets me a strike for cause. And so there are 2 lessons from it. If you can get a supplemental written questionnaire, that's really great. If you can do social media research, do the social media research. If you can do a focus group, do a focus group. If you can't do a focus group, talk to your mother.
I talked to my father-in-law.
Talk to your father-in-law.
Yeah.
If you have kids who are in their 20s or even younger, talk to your kids about the case. And
for clarification, my father-in-law is a really reasonable guy. It's just he understands things as black and white, right? And so it's nice to be able to bounce ideas off of it.
Well, and here's what I'll tell you is that everybody, all of my friends, even people people live in Austin, they all have one Republican friend who they refer to as my one Republican friend.
Yeah, sure. Yeah.
You want to talk to your one Republican friend if you're a plaintiff's lawyer, and then you want to listen to what they have to say. Yeah. So like one of the worst things I think you can do, in voir dire is to be inauthentic, right? Do something cheesy to try to appear to be authentic or appear to be connected, or do some kind of manipulative thing talking about yourself to create some connection or whatever. Let me tell you what connects with people is that's listening to people. And you started out saying, okay, if I were to give one tip to a young lawyer about how to get better at voir dire, it would be to practice listening. And in between undergraduate school and law school, I ended up substitute teaching for about 6 months. And the way it worked in Odessa, Texas, is if you got a call in the morning and you said you could teach a class, then you had a job for the day. And I said yes for 6 months, no matter what. And I would pretend that I couldn't find the lesson plans, and I would stand up and I would stand up in front of the class, and we would do the inquiry method of teaching. And the inquiry method of teaching was to ask questions and listen to the response, and then have a back and forth. And I would do that for 5 hours in the day, right? Like every class period, I would stand up and do that. And people will say to me, it's like, oh my gosh, you're a jury consultant. Can you read body language? Can you read my mind? What am I thinking now?
Are you Bull? Are you behind Bull on
What am I thinking
CBS?
right now?
Yeah.
And what I will tell you is that it's my belief that if somebody says they can read body language, then they are lying to you or lying to themselves.
It's one of the two. Yeah.
Because and same with reading your mind. I'm intuitive. I can read people's minds.
Yeah.
Right. Because the deal is that in order to be able to read body language, you have to have the baseline for that person. So if a person's habit is to cross their arms because they're cold or they don't want you to look at their chest, then them having their arms crossed doesn't mean anything, right? You have to know what people's tells are, and tells are not universal. And so what I can do is I can listen to the words that come out of people's mouths. And since lawyers are such bad listeners, it looks like a miracle.
That's
and this is a skill. It's a skill that has to be practiced in order to develop. So what I do, one of the things that's unique, I don't know any other jury consultant that does this, is I do pro hoc vices when I'm out of state. I do appearances in all my cases when I'm in Texas. And so when there's an argument at the bench, I take my chart up to the bench and I say, juror number 2, my notes say that you're a black and white person and you don't think you could ever quantity this. And that's a quantity because that's what the juror said yesterday. And that you just could, in answer to the question, could you give a number? No, I just couldn't give a number on mental anguish. Are my notes accurate? Yes. Were you telling the truth? Yes. I know you'd try and be fair. I know you'd try and follow the law. I know you'd try and follow the judge's instructions. But when it comes right down to this, you simply couldn't do that. Is that fair to say? Yes, it's fair to say. Now, why did he do that? Because I had it word for word. Mm-hmm. If I had gotten one word off, he would say, no, I didn't say that. You're putting words in my mouth. And the only reason I can do that is I'm highly trained in listening. So I practice. And so here's the thing I'll leave you with is this is the homework assignment for everybody is when you finish this podcast, go to your significant other and say, honey, how was your day? And then listen until the person stops talking. and really be present with them when they're listening. Take it in. And then say, tell me more about that. I'm interested in what you have to say about that. And then let them talk some more. And then say, how did that make you feel? And then let them talk some more. And then when they finish doing that, and don't cut them off. Don't give an amusing anecdote it reminds you of. Don't fix their problem. Don't come up with a solution. Don't give your opinion or critique about what they said. Just listen to the words that come out of their mouth. And then say, what I hear you saying is, and then repeat back word for word something that they said. And if you can repeat back word for word something that they said, you were actually listening to them and not the little voice in your head that's planning what you're going to say next, that's evaluating, criticizing, planning. If you really get word for word. And that's how I end every focus group. Every focus group, I go through with each individual and I say, what in your life most influenced how you viewed the case? Not your arguments, not your rationale. And I cut them off if they start to tell me something different. I say, what in your life experience most influenced your biases, your prejudices, your religion, your parents, your upbringing, your community? What did you bring to this? And then they tell me, and I repeat it back word for word. And man, everybody else sees me. They don't know what's going on, but they know somehow or another I'm actually really with them. You want to be related to a jury. Don't do some kind of cheesy, oh, I see here you're a bowler. I'm a bowler too. Okay. Or I'll read my juror card to you. Really listen to people and be interested in what they have to say. And man, they'll get it.
That's great.
We teach the same thing when we teach depositions, to actually listen to the witness's answer, because, you don't think about what you're going to ask next, but think about the answer and make sure you can play off the answer. Cross-examination as well. So, Robert, thank you so much for all the great information. I literally took notes like I'm sitting in a CLE. So I caught myself making notes. I'm like, oh, I got this case coming up. I need to throw this question in there. So this was really, really helpful. So thank you so much for being on the podcast today.
So great to be with you.
Thank you, Robert.
I look forward to teaching with you again.
Thanks.
So I literally have like pages of notes from doing this podcast.
I want to get like a panel, because I want to bring in someone from, the ranch, or someone who has like the, I guess, Nick Rowley stuff, or any of the other people who are into the brutal honesty. Let's have a conversation. I don't think that the two are necessarily in conflict with each other, but I won't go into that because we've already gone into a lot.
Yeah. No, I agree. I don't think they are.
For me, it's like, well, I want to see people as not having those biases and prejudices, and maybe he's right. And so I need to be open to the fact that, if we're going down a wormhole, it's like inception. I need to be open to the fact that maybe that's a protective mechanism. It's a fascinating topic. And I like talking about it, and I just hope that it's helpful to people who are listening.
Yeah. It was a great podcast, and I encourage you to check out the show notes, visit Robert's website, and, take the Harvard IAT test. We'll put the link to that on there as well. And, learn a few things. So,
yeah. And I hopefully got a lot out of this pod, and know I did. And, these longer ones are hopefully full of information that you can use in your next trial or in your next witness preparation, and reach out to Robert, get that question he was sort of holding back, and, maybe that'll help you next time.
He's got a lot of good ones.
He does.
All right. Next time, Mike.
That wraps another episode of the official Lawyer Minds podcast. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content Lawyer Minds has to offer and engage with us on social media. Your feedback on the show and ideas for future shows is always welcomed. See you next time.